My lords, I appear with Dr. Kweku Ajiman Budu, Budu. Dr. Kweku Ajiman Budu.
Does Ajiman take a C?
No, B-U-D-U. Ajiman. No, without a G. Nana Ejay Bafo Ewa. Nana Ejay Bafo Ewa. A J is a J. Y. E-I. Shadrach Oben hyphen Yaboa. Shadrach Oben hyphen Yaboa. Shadrach ends with a K, my lords. With a K. Nana Benin Akon. A-C-K-O-N. Nana Benin Akon.
I said 5.
Yeah, I did the 5th one.
So okay, so he will be the last one.
He's the last one.
Yes.
Very my lords.
The name again?
Nana Benin Akon. A-C-K-O-N.
Is it Akron or Akon?
Akon. A-C-K-O-N. Akon.
Good. Yes, applicants.
Alos, we have a preliminary legal objection to the propriety of the application. We pray that we take that one first.
Since you didn't file it, give us an idea so that we'll see whether
Okay.
we want to take you down formally.
Very well. Alos, this application was mounted on Rule 61, 1 of CI 19 as amended by CI 124. CI 16, no, 124. And my lords, case of signature, the applicant is mandated. To file the decision with application. It's mandated.
Oh.
With the decision.
Yes, any second ground?
My lord.
Also, this is a point you have made which is well known. The rules say so, not
Yes.
so.
And they did not file
That's right.
it with a decision.
Okay.
My lord, in the case of...
Oh no, I said, is there a second
only
ground?
one point.
That's the ground.
Only 1 point, yes.
No, I think having regard to this is a matter that we have. If the decision is available, we normally prefer to determine it on the merits.
Veloz.
No, what does, since the decision is before the court, or determine the application on the merits, having regard to the nature of the case. So, I think,
Veloz.
no, you see, we don't want to drag on matters which are trite. You have a point, you have made it, but the court has, you have mentioned non-compliance with the rule.
Yes.
And the court has power to waive it. And the court has waived it and said, since the decision is before the court, let's hear the application on the merits. And you have done it. You have argued on the merits.
My lord, this court has taken the decision. That's why for Colombo.
Do you have a supplementary affidavit?
Yes. Yes. Yes, we don't have it. And this court made a decision on this matter of Colombo and indicated that you cannot even file supplementary affidavit. You cannot file it. Let alone to exhibit it. You cannot file it. You cannot file it, my lord. It is here. It is here.
Counsel, you have pointed out non-compliance. We have waived it because the decision is before the court.
Very well.
I want to hear the application on the merits. Yes, applicants.
My lords, we have before you an application invoking the supervisory jurisdiction of this honorable court. My lords,
Yeah, our recording system is working, so we don't have to write everything verbatim.
grateful. My lords, I move in terms of the motion paper the grounds set out in the motion paper, the affidavit in support, yes, my lord, the supplementary affidavit in support, the statement of case, and the exhibits annexed to the application. My lords, our ground for this application is that the order made the orders made by the High Court were made in breach of the applicant's rights to be heard. My lord, the further ground is that the trial judge demonstrated apparent bias and partiality. 3, that there was a non-jurisdictional error of law by failing to exercise the court's powers under Order 55, Rule 5(2) of CI 47 to direct second to sixth interested parties to serve the mandamus application on the applicants who have interest in the subject of the dispute. And finally, error of law apparent on the face of the record, which error of law occasioned a substantial miscarriage of justice to the applicants. My lords, I wish to draw this honorable court's attention to exhibit my lord, to exhibit 5 series. Oh, sorry. My lord, a brief fact I think will be important in this matter. My lord, an application for mandamus was filed before General Jurisdiction 13. Now, at the hearing of the said application, after counsel for the applicant and the respondent announced themselves, I drew the court's attention to a joinder application. The trial judge, yes, the trial judge requested I show him a copy of the joinder application. He therefore asked his clerk, a lady clerk, to come for a copy of the joinder application, looked at it, and proceeded to write his ruling. My lord, the ruling we have exhibited to the supplementary affidavit as the B series. My Lord, in Exhibit B1, the trial judge clearly indicates, and my Lord, with your permission, I just want to read the portion. Page 2 of the ruling. So, therefore, the gender application notwithstanding, it is not safe. An offense rule 20.
Now help us. Which of the applicants' ruling are you reading?
Oh, my Lord, with respect, that's
Mine actually is the rulings are exhibited as Exhibit A.
yes, but in the supplement it comes as Exhibit B series.
Okay, I have it as
In the supplement.
Okay. Now, which applicant's ruling are you talking of?
This is my Lord. This is the fourth applicant's.
No, we have Nana Equia Owusu Afriye ruling. We have
The one I have with me is that of fourth applicant.
Mention the name because we have.
Amenope Philibert.
Okay. Let's see. There's Patrick Yabuama.
That is so, my Lord.
There is Ajay Mensa.
But this one is Expertise Frank Ano Dompré.
This is what we are looking.
Oh, very well, my Lord.
Because that locates it easier for us.
B1.
Anyway, but once we get the name of the applicant.
Expertise Frank Ano Dompré.
Not them.
Page 2 of the Expertise Ano Dompré ruling.
Just 1 minute, just 1 minute. There's so much paper.
So, my Lord, with respect, Exhibit B2.
Okay.
Expertise.
Which one are you reading?
Expertise Yao.
Which one are you reading from?
So, my Lord, I wanted to read Expertise Frank Ano Dompré, page 2
Yes.
of the ruling.
Yes. So now we're on the same page. Yeah.
Yes. So it then says, therefore, the gender application notwithstanding, it is not said an offense under 20 Rule 14. The application is granted as prayed, and the respondent hereby is ordered to collate and declare the winners of this election. So it proceeds.
Yeah.
My Lord, again, in Exhibit B2, Expertise Patrick Yabuama.
Yes.
At the same page 2. Quote, therefore, the gender application notwithstanding, since it is not said an offense Rule 20, the application is hereby granted.
Yes.
Exhibit B3.
Now, so, and your point is?
The point we are making is that at all material time, the fact that was before my Lord was that the applicant herein, whose interests will be affected by that decision, ought to be heard. And that failure to afford them a hearing before the decision was given offends the Odi Aterion Party rule. And that offense cannot be cured and should result in the invalidation of the decision by the trial judge. My Lord.
Counsel.
Yes.
So you hinge it on the application for joinder. failure to grant you a hearing is anchored in your application for joinder.
No, my lord.
Is that the case?
No, my lord. First of all, my lord, I just want to draw the court's attention to something.
Yes.
Order 55.
Yes.
Says 2.
No, let's look at the issue of joinder first.
Okay.
Yes. So as far as the failure, alleged failure on the part of the trial judge to hear you, your case is anchored in the application for joinder, whether partly or wholly.
No, my lord, maybe partly.
All right.
Even without the joinder, with respect, even without the joinder, by reason of the provisions of Order 55, 6, Rule 5, 2, it says that a notice of application shall be served on all parties named in the applicant's affidavit as being directly affected by it. 2, the court may order that the notice of the application shall be served on any person not named as being directly affected by the application if in his opinion it is desirable so to do.
So that is the Order 55 prescription.
That is 55 prescription.
Yes. And you mentioned the joinder application, so I'll bring you back. Now, your application for joinder was based on Order 4. Was that the case?
That is correct.
If you have your rules with you, look at Order 4, Rule 5. Order 4, Rule 5, Sub Rule 5. You may start from Order 4, Rule 5, Sub Rule 3. The provisions there indicate what must be done when the court decides to grant an application. Can you read 4 Rule 5.5?
Yes. Okay. It says, where an order is made under sub-rule 2, the writ shall within 14 days after the making of the order or any such period as may be specified in the order be amended accordingly.
So, yes.
Endorsed with the reference to the order in pursuance of which the amendment is made and with the date on which the order for the amendment is made.
So it talks about a writ.
That is correct.
Yes. Turn to Order 82. A writ has been defined by the rules. I think it's the very last word.
Yes, the definition.
Under the interpretation section.
Yes.
What does it say?
My Lord, it says a writ includes a writ of summons, statement of claim, or a petition in a cause or matter.
So it doesn't include the application before the trial judge.
My Lord, it's an originating process.
Yes, but it's not a writ, as defined by the rules.
You see, my Lord, the word used is includes.
Now, would you say that the provisions in Order 55 are cognizable to the joinder and Order 4?
My Lord, the provisions
Yes.
of Order 55.
Yes. Because you see, by your own showing, Order 55 has prescribed means by which the court can hear a party whose interest will be affected. You understand?
Yes.
By service of the affidavit. So would you say that that provision, an application under Order 55, will recognize a joinder application under Order 4?
My Lord, it should. And my Lord, the reason is that, my Lord, with respect, the reason is that the rules on joinder,
Yes.
unless there is a specific provision detailing how an originating process should be done differently other than Order 4 is applicable. And my Lord, if you look at the reasoning of the trial judge,
Yes.
he did not reason that the application was brought pursuant to Order 4, for which reason he was not going to hear it.
Having said that,
So I'm just pointing out.
I was asking
So,
whether, given that Order 55 has prescribed a means by which the court may hear a party whose interest will be affected, there is a need to even call in Order 4, and whether Order 4 has legal basis
my Lord, a quick
in
response.
a judicial review application.
My Lord, we
before the High Court.
notice that the issue of natural justice
Yes,
is a constitutional matter,
yes,
and the rule cannot, as it were, defeat the intent of the Constitution. That to the extent that a person will be affected by a judicial decision, that person ought to be heard,
yes.
with or without the rule. And so the issue of the rule coming in aid, with the greatest respect, does not even arise. We are raising a fundamental question that relates to the rules of natural justice. It cannot be said that Order 4 or any other rule, if not complied with, satisfy the requirement of hearing. It cannot be the case, with the greatest respect. 2.
Yes, proceed.
In addition, my Lord, even without Order 4, my Lord, it is even in the interest of justice and fairness, which this court is supposed to uphold, that a person who will be affected must be heard. And in this case, with the greatest respect, that was flatly ignored. And so, my Lord, the point we are making, that decision or the orders founded on that refusal to hear the applicant, even when they themselves came to the court. My Lord, should not, with the greatest respect, be endorsed, because the precedent will be dangerous as far as the rule of law is concerned. My Lord, 2.
How, in what sense will the precedent be dangerous?
No, my Lord, the point I'm making is where a party, in fact, maybe let me put it this way, 2 parties can actually collude and overreach a person who will be affected. And that precedent is dangerous. And in this specific case, when the application for mandamus was moved, the judge asked counsel for the respondent, are you opposed? He says, no, I'm not opposed.
Does that make it?
No, I'm not saying so. My Lord, I will say so. My Lord, I will say so. But the point is that if this is allowed, that possibility is so grievous and present. And that is why this court must deprecate, with the greatest respect, that conduct.
Also pay attention to the affidavits in opposition,
Yes.
and then the statement of case in opposition.
Very well.
Address them.
My Lord, with the greatest respect, and I want to draw this court's attention to judicial review application. Or judicial review application. My Lords, exhibits attached to our judicial review. My Lord, we attach exhibits, that's the Republic versus High Court, Electoral Commission respondent, National Democratic Congress. My Lord, it's in the supplement. Yes, so my Lord, I'll be very specific. supplement.
Is it a problem you have created for us? Some of the exhibits, I have them as B, and my other I have it as A or C. Is the problem you have created for us?
My Lord, I'm sorry. I'm sorry about that.
Unlike the other parties who have actually flagged.
My Lord, that should be Exhibit D in our supplement. Is the application for judicial review by the NDC.
Yes, you make the point and let's see if it will help us locate
Okay, okay. My Lord, in the said exhibit, the applicants had applied for judicial review, whereupon they have indicated that there have been declarations in their favor with video evidence of those declarations. With video evidence of those declarations.
Yeah, but those were not before the judge who determined the mandate.
They were before him. My Lord, they were before him. Yes. I stood up. Yes, my Lord. That's the unique thing. I stood up and brought to his attention that, my Lord, pending before you is this application. So we even filed ours on the 16th. On the 16th of December. This mandamus application was filed on the 17th. But my Lord chose to hear the mandamus that was filed on the 17th. Yes. It was in the court and before him.
Please, the two are not the same.
Oh, okay.
Was it pending in that court or it was right before him?
My Lord, it was pending.
Say so.
And he was hearing that same day.
Or it was listed for hearing?
Yes, that same day. So I stood on my feet and drew my Lord's attention. Now, my Lord, these are declarations with video evidence. So consider my application first. He ignored it.
I lost respect.
Yes, Counsel.
You see, some of the facts being heard on this court are indeed erroneous. They are erroneous. And I think it's fair that I put them in context. Okay. The process he filed.
Counsel, you can read.
No, just hold on.
Please. What he filed was not before the judge. It was not before the judge.
No, it may not be on that
She was
docket.
listed.
It may not be on that docket, but it may be in a separate docket.
No, brothers. He came to court holding the documents.
No, we're talking about the second application. Or the
application?
The first application, the one they filed on 6th.
The one they filed.
The first application. Okay. So, Mr. Tamaklo,
Yes.
continue.
So, my Lord, at the time my Lord considered, he had before him video evidence. And in fact, when I brought it to the attention of my Lord, he indicated in open court that the docket was just brought to him the evening. And in fact, that application, I moved it together with my learned senior. After he had granted the mandamus application, he now asked me to call that.
Oh, okay. So he heard it.
Yes. In fact, I even made a prayer that, my Lord, I beg you, watch the videos. He said he will do it. And started giving his ruling. So, my Lord, at this point, clearly before my Lord, was evident that some people have already been declared during the mandamus. He knew that that would definitely affect their rights. My Lord, on the grounds the grounds of bias. My Lord, the point we make here is that at the time, with respect, my Lord was considering the mandamus application. He knew that any order would immediately affect the application which we have exhibited, which was pending before him, but gave a decision in such a way that by the time he is done hearing, our application for judicial review would have become moot. Manifest bias. My Lord, 2. The mandamus application, in one breath, my Lord says our agenda on page 2. Offense under Rule 14 of CI 47. However, my lords, the mandamus application that was granted, with respect, had no statement of case attached. So, in one breath, my lord was holding us to the strict compliance of the rule, but in the other breath, waive it for the interested party. My lord, without the statement of case, the court's jurisdiction for the mandamus was not properly even invoked. And so the orders founded on it were definitely done in excess of the court's powers or its jurisdiction. We submit.
What is your authority for saying that?
Bible 65:06. 2.
It says what?
6:2. The court may, on the hearing of an application for judicial review, then 2, within 14 days after the filing of the notice of application, the applicant shall file such numbers, such copies of the applicant's statement of case. And my lords, this court, in the case of and Nitete Ahinkwa II and Thomas Okai, civil appeal number J4 2009, dated 29th April 2010. His Lordship Justice Badegbe had this to say, that when J4/20/2009, it was dated 29th April 2010. It says, quote, where the rules of court prescribe a particular mode of seeking relief, then a failure to initiate the proceeding for relief in accordance with the prescribed mode is not only an irregularity, but raises an issue that goes to jurisdiction. Now, in excess of jurisdiction, specific. In the case of Francis Owusu-Mensah and another, versus National Board for Professional and Technical Examination, civil appeal number J4/57/2010, 2017, dated 1st May 2018. It was held.
House of 57 or 67?
57. Eniegwa JSC, as it then was, had this to say: a court may have jurisdiction to entertain a cause or matter, but the procedure invoking its jurisdiction may deny the court's jurisdiction. In this case, the court, the High Court, has the jurisdiction to entertain a mandamus application, but the rule says, at the hearing, a statement of case must be attached to the application. That is how the court jurisdiction is invoked.
Mr. Tamaklu,
My Lord.
even in this court, your colleague raised a fundamental issue, preliminary objection, which we have waived.
Oh, my Lord, I take it that you are willing to waive this one.
And we said that, look.
No, my Lord, when you waived, it was on record as having waived it.
So it's...
In this case, my Lord, the ruling of my Lord is before you. The court never said they are waiving that non-compliance. My Lord, the court never said that. It is a different thing if the court, in exercising its powers, gave an indication on record that it is waiving that non-compliance. That was not done. My Lord, it's a court of record.
Yes.
My Lord,
In fact, does it matter to you that the other side did not file an affidavit in opposition? Does it matter to you
yes, my Lord,
that the EC before the High Court was not opposed to the application?
my Lord,
Therefore, the waiver even started with the EC.
no, my Lord, the waiver is not one that the party should raise, with the greatest respect. It's not one that requires that a party should raise an objection to the non-compliance.
The party may raise it.
Yes, I'm saying that without that, this court is required to consider it.
Yes.
Yes, my Lord, what we are basically saying is to just draw this court's attention to the nature of the bias. That in one breath, he holds us strictly to the rule. And my Lord, that is even denied. The joinder application had a certificate of exhibit with the greatest respect attached to it. Yeah. Yes, yes, yes. I'm not afraid there was no yes. So, my Lord, I'll just read the ruling.
Oh, no. Which one? On your non-compliance with the rule?
No, the issue of the manifest bias.
Okay.
My Lord, Exhibit B series, ex parte are not on prayer.
Yes.
But Lord, there was no exhibit attached. So the issue of certificate of exhibit does not even arise. But my Lord said we had offended the rule.
Okay.
My Lord, 2. Ex parte Nana Equia Owusu Efriye. That one, we attached a video recording of the declaration. And there is a certificate of exhibit attached. But my Lord simply says he is applying the ruling mutatis mutandis. My want to bring to your attention the decision of this court in the Republic versus High Court Bogatanga. Ex-party Hawa Yakubu, 2001-2002 Supreme Court of Ghana Law Report at page 553, sorry. The Supreme Court had the occasion to quash the orders of the High Court in Bolga because the court said Hawa Yakubu, who had been declared winner, was not a party to the petition, but orders were made which adversely affected her. Even though she was not a party, the court said she had the right to be heard, and that right was breached. And all the orders made by the High Court in Bolga were quashed. And the resulting effect that all the consequential orders, having been founded on those orders, must collapse with it. My Lord, the affidavit in opposition filed by the first filed by the Electoral Commission. The position made is that because
proceed.
Because the applicants were not parties at the time the application was heard, they deserve no rights, or there's no issue of breach of the rules of natural justice. My Lord, that is completely far-fetched. Because the application for judicial review, which had the video recordings of those declarations, was duly served on the respondent. The respondent came to court and said they were not opposed. They never filed any affidavit denying those declarations. Or he only stood up and said he's opposing it on point of law. The factual basis of the declarations were never denied. So they claim that they were not parties and therefore should not be heard. There is a new. And that is exactly the decision of the Supreme Court in ex-party Hawa Yakubu. My Lord, at this point, my Lord, I want to make a brief prayer that certain depositions in the affidavit in opposition by the Electoral Commission, deposed to by Mr. Samuel Tete, be expunged from the records of this court.
Why?
My Lord, these are matters that are not within his personal knowledge. He is not the returning officer of any of the constituencies named.
I think he preceded his affidavit by stating that within his knowledge and information, didn't he?
My Lord, the point we are making is that, with the greatest respect, my Lord,
Yes.
one, he does not attach any official record or official document to the deposition, or a police report by any of the returning officers detailing the so-called
Yes,
arrest or fraud.
that weakens the weight.
Very well.
I don't think we...
No, my lord, I just want to bring it to us.
Okay.
That those depositions should not be responded to.
Oh, no, we said that, the man stated that to his information. If he thinks that it doesn't actually establish a fact, that is a different matter. But you can't, you don't say we should expunge it.
My lord,
Yeah.
the respondents say they had already done the collation. And so what is the point, you considering our application? My lord, the morning of that Friday, with the greatest respect, I had appeared at General Jurisdiction 6 with my learned senior Justin Amenuvo and Gary Limaku, where there was a pending injunction application against the Electoral Commission. That it, my lord,
my lord, so far, various allegations have been made in this court in the course of his submissions, which have not been deposed. I hope that when it gets to my turn, the court will permit me to give alternative facts, because he's been going on and on and on.
No, counsel. If he is saying something which is not in his affidavit, it is your obligation to point it out, and then we would do the needful. So anytime he's going beyond his affidavit, draw our attention. Yes, counsel.
Mr. Tam, yes.
We have a...
Please restrict yourself to your affidavit and let's go on.
Yeah.
yes, my lord. So,
We don't
my
have
lord,
the whole
no,
day.
my lord. So our response is that at all material time, there was a pending injunction application that we had all appeared before the judge and gave us Tuesday.
My lord, this is not before the court.
Okay. So you haven't deposed...
It is not in your affidavit.
You haven't deposed to it. So let's go on to another point.
My lord,
you were addressing us on what you said is the argument that the declaration has been done already. So address
my
it.
lord, our quick response is that, in fact, in the Hawa Yakubu decision, orders were made, and those orders were even complied with. But when it was brought to the attention of the Supreme Court that there was a fundamental breach of the rules of natural justice, the decision and all the consequential orders founded on it were all set aside. My lord, it is on this basis that we make this prayer. Yeah, I'm the most. So, my lord, it's on this basis that we invite this honorable court we urge on this honorable court to quash the orders of the High Court General Jurisdiction 13, my lord, maybe just a quick point. In paragraph, my lord, with respect, in paragraph 10 of the second to seventh interested party affidavit in opposition, particularly paragraph 10, it is deposed to the fact that our agenda was heard.
Yeah, that's their case.
That our agenda was heard and dismissed.
Yes.
My lord, with the greatest respect, the agenda application was treated in a very cavalier manner. Cavalier. In fact, it was not moved.
The problem I'm complaining about. What you are alleging, my lord, is not captured in affidavit.
Is that paragraph what?
To the paragraph where you said the joiner was heard. A joiner which was on the docket, how can it be heard?
No, I think their case is that the court gave you a hearing.
Yeah, that's what I'm responding to. And I'm saying that we were not heard.
So it's different from saying that the
Very well. We were not heard. And my lord, nowhere in my lord's ruling did he hear say with respect that he heard our agenda and dismissed it. Nowhere. In fact, he himself said he will not allow the agenda to affect the quick hearing of the application. How can that same agenda be deemed to have been heard?
No, he said he gave you a hearing on the application.
Yes, my lord, and that is why we are.
So it's not a joiner. He had before him an application for mandamus. Their case is that when you appeared, he heard you on the application for mandamus.
No, my lord.
No, I'm trying to get you to understand their case. You are misrepresenting their case.
Very well. So, my lord, the point we are making is that we were never heard on the application for mandamus. Because first we were praying that we will first be joined, then we'll be heard.
Mr. Tomekulu, I'm reading something from Nana Akua Owusu, a 3 years exhibit. I think it's the first one.
My lord, 1 minute.
Yes, I have it as A series. The one in respect of Nana Akua Owusu Afriye.
My lord, I want to just locate my.
I believe it's in yours as a B series.
Okay. No. Okay. Yes.
You found that?
Yeah. Is it the mandamus application?
Yes, the ruling, yes.
And the ruling, oh, okay, we attach it to our supplement. That's the B series.
Yes, I have it as A series, but it's fine. But the one in respect of Nana Akua Owusu Afriye.
Yes.
Have you seen the ruling?
Yes.
Please read the first paragraph of that ruling. It's in connection with whether or not you were heard.
So,
can you read it?
Yes. The application on the face of it is not different. And notwithstanding the submission of a friend of the court in the person of Godwin Kudu Ebiji Tamaklo to the effect that the winner of this constituency has been declared. And he proceeds, which no evidence is before the court, except an application yet to be moved.
Yes.
Yes.
So you made a submission.
No, the submission is to draw his attention of the pending joinder and the judicial review. And notwithstanding bringing to his notice. In fact, he described me as a friend. A friend of the court. At that point, I was not counsel for a party.
No, but you were not. You were not a party to the application. Perhaps that was why he decided to grab you as such. Yes.
No, my lord should see representation. You see that there is no record of me being a representative. See, counsel. Oh, my lord, just to draw his attention.
Anyway, we still have two other lawyers here. So
my lord,
you
so,
wind up.
My lord, on this basis, so my lord, this court has on many occasions upheld the fact that a person to be affected by an order or a decision should be heard. My Lord, within this context, a failure to do that, my Lord, will be a serious affront. That affront to the rule of law, constitutional the other party. The Supreme Court, and my Lord, I conclude here. The Republic versus Court of Appeal, Anthony Tomford, ex parte Ghana Chartered Institution of Bankers, 2011. 2 SGLR, page 941. The Supreme Court, speaking through His Lordship Justice Atuguba, held that the terms of Article 296 are mandatory and obviously require the observance of the rules of natural justice, especially the Odi Ateron Parting rule involved. That Odi Ateron Parting rule has been elevated to constitutional pedestal, and this breach has constitutional consequences. My Lord, and said breaches void the act in question. My Lord, it's on this note that I draw the attention of this honorable court with respect to grant the application as prayed.
All right, thank you. Counsel for.
Yes, my lords. My lords, we are opposed to this application and rely on our affidavit in opposition and the statement of case in support of that affidavit in opposition. My lords, except to add that properly so called, there are 6 applicants before the court. But my lords will observe that none of them, not a single one of them, has deposed to an affidavit in this court General Decision 13 just saying that Electoral Commission go and perform and complete your constitutional duty. None.
Oh, you mean the individual applicants?
Yes, my lords. There's none before you. They have not deposed to
How about the first applicant?
My lord, the first applicant is not a party who has stood for election and for which he is claiming that he has an interest. He's an official person. These are individuals. The first applicant will not go to parliament. These are individuals. They are before you. They have not said anything. My lord, well, he said he has sponsored. Let the sponsorees, it's the sponsorees who go into parliament, not the sponsorer. My lord, the second point I'm making is that I'll refer the court to the case of Bobier versus 21st Century Construction Limited. Another civil appeal number J4/5/2014. It's a judgment of this court dated 9th March 2016. Suit number J4/5/2014. It's a judgment in which my Lord presiding and his brother now retired Justice Badebe delivered the ruling, and their ruling touched on the effect of Order 5, Rule 1. my Lord, with respect, order 4051. And with your kind permission, if I may read.
CI 47.
Of CI 47, my lords. No proceedings shall be defeated by reason of misgender or non-gender of any party, and the court may in any proceedings determine the issues or questions in dispute so far as they affect the rights and interests of the person who are parties to the proceedings. My lord, even if we transpose this originating notice application into a writ, by this rule, the court has the right.
But it was not a writ. Why do you try?
No, that's why I use the word even if.
Okay.
Even if we do that, the non-joinder will not defeat the proceedings. The court has a right to go left or right, and if it does, their course of action is one of appeal. So far, in the submissions, I have not heard any submissions to say that the judge erred, and that error is on the face of this record and is jurisdictional, and therefore certiorari should lie. Respectfully submitted. Thank you.
Oh, counsel.
Right.
But you argued Hawa Yakubu in your. You argued Hawa Yakubu.
Yes, my lord, I did.
And Hawa Yakubu, the decision was that if the party in an election will be affected.
No.
No,
my lord, the order had an injunction placed, but in this particular matter, it doesn't apply on all fours simply because the EC was told, go and finish your work.
Yeah, so I agree with you that you can't question it on non-gender, but you can question it on other parties.
Yes, my lord.
As happened in Hawa Yakubu.
Yes.
And I read your submission where you try to distinguish Hawa Yakubu.
Yes, my lord. And then also, one last thing, now that you have brought it up, my lord, the application that they exhibited, that they had an application before the court. What they haven't done conveniently is to also attach the ruling of the court. They have just exhibited the application. So yes, my lord will look at it as an application. My lord, there is an application because of the way the numbering is managed. I'm not able to. It is an application. Let me give you. My lord, let me give you.
Counsel, take your time.
Oh, my lord. Well, my lord, this is the application dated 16th. It was filed on the 16th of December 2024. My learned friend made reference to it. But in that particular matter, he hasn't brought the ruling of the court. There is a ruling of the court on that particular application. So, my lord, to wrap up, none of the applicants before the court has made. Yes, thank you. I'm most grateful.
Okay. Thank you very much for saving our time.
I like the word mania.
Yes, Mr. Nimako.
My lords, we are also opposed to this application. We filed a freedom position case on the 25th of December 2024. We rely on all the positions made in the affidavit and the exhibits attached. And the authorities listed in the statement of case. My lords, application on the document of the court, which all parties to the action were not served with a said application at the time when you were dealing with the mandamus application. My Lord, we submit. The application for joinder was indeed a non-starter. That is because, my Lord, there are specific rules dealing with mandamus application. And my Lord, in Boifio, this is 8 years for properties. Boifio, this is 8 years for properties. 1996, 97. IGLR 531 at 533. This court held that the law was clear, that where an enactment had prescribed a special procedure by which it was that procedure alone that was to be followed. My Lords, Order 55, Rule 5.2 has provided for the procedure by which notice of an appeal for judicial review can be communicated by the court to any affected party. That procedure is not joint application. The court may order that notice, and it is may order that notice of the application shall be served on any person not named as being directly affected by the application, if in its opinion, an opinion of the line, it is desirable that the person should be given notice. It is a rule, my Lord. It is a rule, not by joint application. And my Lord, this is a discretion which a court has to exercise. It's a discretion. It's a discretion. And if the court exercises discretion, whether rightfully or wrongfully, the aggrieved party, if so minded, cannot come by judicial review. The nation should arrive.
What is your authority for that?
My Lords, if I may refer this honorable court to page 3 of my single case. Page 3. Republic versus Court of Appeal, Especially 2005-2006.
Oh, read the report.
Read the report. Very well.
If you have the report there.
Yes, yes. The clear thinking of this court is that.
What page are you quoting?
Page 619. 619.
Yes, yes.
The clear thinking of this court is that House Supervisory Jurisdiction and Article 132 relating to Constitution should be exercised only, in the word underlined, only in those manifestly plain and obvious cases where there are patent errors of law on the face of the record, which errors either go to the jurisdiction or are so plain as to make the jurisdiction a complete nullity. My Lord, if I may even
now, I get the point, but you see, you would agree that the ex parte Chachuchikata case and the ground that was being discussed by Georgina Wood, JSC as she then was the ground of error of law. Let's pay attention to the fact that they also have a ground of failure to observe the odi alteram pattern. So, yes, if it comes, your point holds. But also address the area of the failure to observe the odi alteram pattern rule.
Yes.
You have argued it, but I think you should expatiate on it.
My Lord, we stop it. That a non-party to a suit cannot complain. That his right to fair hearing has been breached. In this case, my Lord, I saw the Republic versus High Court, Accra. High Court, Accra. Ex parte, Danso, and others. In 2015, 2016, one LGLR at page 760. 760. One Supreme Court of Ghana law report at page 760. Holding one. This court held in dismissing application for judicial review as follows. That instead of the first ground by the applicant alleging breach of the right to fair hearing being a fundamental right that is available to parties to an action, this court is unable to extend its scope to persons who have not, on the record, yet become parties strictly so as to speak. My lords,
but there are several decisions. Republic versus Koligono Magistrate, ex parte Amponsa, which has been cited by Amenuvo. They said that as for certiorari, their public law reliefs, you don't have to be a party. And then we have
it's about capacity. It is an order.
No, I just want to say that the general blanket statement may not be true because there are alternative authorities. If in this case you want to make a distinction, fine, but judicial review is a public law relief, a non-party can come for it. Ex parte Adavali and so many other cases.
Yes,
but make your point.
Yes, so the point we are making is very simple. The High Court only made an order directed at the public body to perform public function. To simply go and collate and declare a winner of a public elections. And my Lord, I believe that all of us here are interested in who is the winner or a loser in our elections. So that order, which the court made, for the EC, the first to go and collate and declare who has won or who has lost. My lord, it's a public function. Public function. How does that order to go and collect and declare the winner or a loser of our elections affect somebody injuriously?
Oh, look at your Exhibit 9. Look at your Exhibit 9. D9. Your Exhibit D9.
Yeah, my lord, maybe D9.
Yeah, D9 is supposed to be, I don't know what I would call it, the collation sheet.
Yeah, it's a public document.
The collation sheet.
Which is a parliamentary election results summary sheet.
Yeah, now look at the last part. You know, that form has got the various candidates.
Yes.
And the marks or votes that they scored, right?
Yes.
Now look at the lower part, where provision is made for the candidates to sign or refuse to sign. Because the refusal to sign means that a candidate may disagree with the collation and would want to raise an objection. That is considered and entertained by the Electoral Commission themselves. So how do you say that the order to collate doesn't affect third parties?
My lords, with all respect.
Because they have a right even at the administrative level to object.
Yeah, my lords, under the CI 127,
Yes.
if a party decides not to participate in the process,
Yes.
it doesn't stop the EC from performing their function.
Yeah, but what we have here in your Exhibit D9 is the sheet which has only the MPP parliamentary candidate's name, his agent, and his signature. There is nothing about all the others. There is no reason why they did not sign. So the point I'm trying to make is that even the form of the Electoral Commission entertains the fact that in the coalition, the other contestants will have an interest.
My lords, with all respect to you, to the bench, this document, D9 that you are referring to, this becomes relevant when the results are gazetted and you want to challenge the result of an election petition. Petition. My lords, with respect, at the time when the court was making an order for Madam's application, this exercise I don't be effective. But now, personally,
I'm just trying to say that what the applicants are saying is that they stood to be affected, and you are saying that they would not be affected. The Electoral Commission is saying that they will be affected. That's why they have this form, which makes provision for them, for all the other candidates. So the Electoral Commission, Mr. Mirubo, you can also comment on it. Because you didn't exhibit it, I didn't want to spring it on you, but it was exhibited by the 2nd to 7th interested parties.
Yes.
Yeah.
So my lords, I mean, this particular exhibit D6, 7, 8, and 9 is contained therein were not factored in at the time when the court making an order that proceed to go and do collation and declaration.
Okay. Agreed.
Mr.
Mirubo, if you
my lords,
yeah, that's right. No, just one point. Mr. Mirubo, if you have those exhibits, I think you should check them well, because D10, the form there is a bit different. So it will be of interest to you. You know, the D10, the form doesn't contain the portion for stating the reason why you
yes, my lord. I will.
So it's of interest to you.
Yes, my lord.
Okay, thank you. Yes, Mr. Gary.
Yes, my lord. So, my lord, clearly. The point I'm making is that if there's public elections as they conducted in all polling centers, not declared in all polling centers, what is left is collation and declaration, summation of the various results in the various polling stations. Why should it be a problem, my lord? What's the problem? Why should it,
We don't know.
why should the EC? So, because the point that we are making, granted without even admitting that the application for joiner, which we have said, my lord, is a non-starter, but the rules don't provide for joiner applications. If the judge has been aired, granted without admitting, the judge has been aired, the real cause of the petition of the applicant is appeal, not judicial review. And the judge should arrive. I just want to do it before you this morning. My lords, again, one other friend made a point about where's the rules book? About we not filing a statement of case. Thereby making the application and the judge being biased. Refer my laws to Order 55. Two, 3, of CI 47. That within 14 days after filing this application, the applicant shall file such copies of the case as the registrar shall determine, setting out fully arguments he wishes the court to consider. My lord is the registrar. The registrar. Now, if the applicant does not file statement of case within the time stipulated under Sub 2, the registrar shall certify that fact to the court, which may dismiss the application for non-prosecution or make such other order as it may consider appropriate. There is nowhere, my lord, that the non-filing the statement of case deprive the court of jurisdiction to detain the application that was before it, to the extent that the registrar or the court, which was supposed, if it was desirable to do so, made no such order. In any event, my lords, the respondent, that is the EC, that was supposed to go and carry out its constitutional and statutory duties, they did not put application. They took the view that yes, they wanted to go and do their work. And indeed, my lords, they have gone to do their work, declare the winner, declare the loser, and the matter is foreclosed. Oh, foreclosed.
If that were the law, the illegality will persist forever.
My lords,
so I'd like your other arguments, but as for foreclose,
my lords,
your other arguments you have answered substantively.
My lords,
Yeah.
My lords, an order by a court to proceed to perform a constitutional and statutory function.
If it's set aside, that would be the consequences are clear in the authorities. Anyway,
with respect.
Yeah. Your other points I will take, but as for this one,
yes.
Yeah.
Further, my lords, it is not the applicants that were going to perform the said constitutional duty. Not the applicants. It's the first interested party. So granted, which I already indicated that the joint application was not funded by the rules. Granted. there will not have been an NDC party to the action. Granted. Because the application was directed at a specific body, the EC, and no one else. And no one else.
Now let me pick your mind on something the trial judge said in the ruling in respect of the application by Nana Equia Owusu Afriye. If one of your assistants can open to that. The ruling in respect of the application by Nana Equia Owusu. Yeah, B series. Now, if you can read the whole of paragraph 1 and it extends to the next page, read it and.
Paragraph 1.
Yes.
SBB series. The application on the face of it is not different, and notwithstanding the submission of a friend of the court in the person of Godwin Eduji Kujo Tamaklu, to the effect that the winner of this constituency has been declared, and which has no evidence, and which no evidence is before this court, except an application yet to be moved. It is observation of this court that the respondent will not be affected if indeed it has been declared already.
Now you stop.
As it stands.
No, just now you stop there. You see, this conditional, if it has been declared already, where does it leave us? Because the applicants are contending that it was declared already. And then she is saying that if it has been declared already, then this ruling doesn't change. I'm finding it difficult.
Alos.
Uh-huh.
Alos.
Yeah, you were there, so probably you.
Yes, alos. The application, my friend, far before you. If you look at all the exhibits which they have filed, my lord should realize, what is all this? My lord should realize that they have not, or they did not, what is this? They did not, no, our application, our affidavit, yes, they did not attach any parliamentary election results summary sheet to demonstrate that, in fact and indeed.
Oh, we hadn't reached that stage. Because
then direct me properly.
no, the point I'm making is that the judge is saying that if there had been a declaration already, then the person whom it was first declared for would not be affected by this ruling. But that is a very risky, slippery ground.
My lord, the bottom line is that, let's say, even there was even a declaration, in quote, but there was none, in quote. If the collation is done and you won, it will be confirmed that indeed you have won.
No, the judge said it will not affect her.
No.
Anyway, it is not your writing. It's because you were there, that's why I wanted you to react.
There is no way that if you win an election, the results will change. If you have won, you have won. If you have lost, you have lost.
Anyway, that is the dispute. The dispute is whether the first person won or the second person. So that's the dispute. But I must be honest with you that the application before us, we are not in a position to resolve the factual dispute.
That is true.
As to whether the person who was first declared or the person who was second declared. We are not in a position to resolve that dispute. Ours is to look at the legality of the proceedings that resulted in the order for the Electoral Commission.
Yes.
Yeah, so wind up and then.
So, my lords, in conclusion, I submit that another High Court judge was acting within a jurisdiction there is no error of law patent on the face of the record, which errors goes into jurisdiction, which is so plain to manifest a nullity. There was no breach of natural justice. So, my lords, we submit forcefully that the High Court judge exercise a discretion. If the applicants are agreed about the discretion so assigned by the High Court judge, their remedy lies in an appeal. And not my lords, we submit accordingly.
Thank you.
My lord, just a quick, okay. My lord, with your leave, just one point of law. My learned friend in his concluding statement says, our remedy lies in appeal. My lord, with the greatest respect, without being joined and being a party, we could not exercise the right to appeal.
Authority to give him. I have authority to give him to go to an appeal. Is it there? And I will give it to him. Yes. 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 The authority is there, I'll give it to him.
The court will take a short break. All rise.